Welcome to the I Got Fired podcast, a podcast for people who've been fired or afraid that they might be. I'm Tom Spiegel, the founder of the Spiegel Law Firm and host of this podcast. And today we're going to be continuing our series on litigation, on the litigation process. And we're going to be talking about summary judgment. But before we get into that, just some housekeeping details. This is intended to be for educational purposes. It's not intended to be specific at legal advice for you. If you need specific legal advice for your matter, then you got it. You should go consult with an attorney. All right, so let's dive in. Summary judgment. Previous to this point, we've talked about the other steps along the way in the litigation process, filing the complaint, getting the answer, the motions to dismiss that may occur in that time period, discovery, both paper discovery and depositions. And now we're to something called summary judgment. And what this is this is a procedure by which usually the defendant can ask the court to essentially rule in its favor, what we call the merits of the case. And what the defendant is usually saying is that that no reasonable juror could look at this case and rule in the plaintiff's favor. Now, it's possible for the plaintiff also to file for summary judgment, but it tends to be more rare. And for in employment cases, it usually is the defendant who is the one who is going to be filing this motion. Although we have on occasion our practice filed it, but it's usually the defendant. And this is governed by the Rule 56 of Civil Procedure. And I want to talk about the ways that this rule should apply and what the kind of the textbook answer is and some of the practical realities of summary judgment. So let's talk about kind of the textbook version of summary judgment. So summary judgment, the court is supposed to be deciding, this is the 25-cent legal phrase, whether there is a genuine issue of material fact upon which a reasonable juror could rule in favor of the plaintiff. And what that means, so let's talk about, genuine issue of material fact. So a genuine issue is like there's really a dispute. This isn't like you guys are like sort of disagreeing, like it's an actual point of contention to a material fact. And that means a fact that is relevant to the lawsuit, to the elements that the plaintiff has to prove to win his or her case. Summary judgment can be total. So, judge can kick your case out completely at summary judgment, or it can be partial. So the judge can, let's say you've got 4 counts and one's a Title VII race discrimination claim and one is a Section 1981 race discrimination claim, and then you've also got retaliation. And the judge can look at it and say, you know what, I don't think you have met the threshold for a Title VII claim, but I'm going to let you move forward on your Section 1981 and your retaliation claim. So a genuine issue of material fact would be, well, let's use a kind of a silly example. Let's say everybody in the case agrees that parties disagree about whether the Washington Commanders are a good football team, right? Well, one can have really strong beliefs one way or another on that, and it's just not relevant to the lawsuit, right? I mean, who cares in terms of this lawsuit? So is it something that the parties disagree on, and is it relevant to an issue in the lawsuit? Let's use an example in an employment law case. Let's say that there is an issue of whether or not there's a contention about whether or not a manager used a racial slur to refer to someone that he worked with, right? And the argument that the plaintiff is putting forward, the employee in this case, is that, I didn't get that promotion because I was racially discriminated against. And as evidence of this manager said used this racial slur, and the manager denies it. Okay, so that is a genuine issue of material fact. The fact is important to the outcome of a lawsuit, and parties are in opposition to each other on that. So in the motion, in most jurisdictions, they require you to go through and parties to list the facts that are in contention, and to agree at least that the facts are in contention to the extent that you can. And then they all have another section where there are perhaps facts that you think are in contention that the other party does not. So the court, they really kind of laid this out in kind of brass tacks. The way that the court is supposed to rule on this is they're not supposed to act as a juror, right? So they're not supposed to look at the case and say, you know what, I think that the manager did use this racial slur, and that therefore there is sufficient evidence of racial discrimination for me to rule in favor of the plaintiff. What they're supposed to do is to look at it dispassionately and say, could a reasonable juror, whether I agreed with this juror or not, could a reasonable juror find in favor of the plaintiff, or the non-moving party, the one who's about to get their claim kicked out of court? Because it should be a higher standard, right? You're preventing somebody to get the opportunity to get in front of a jury. So the idea is that, as long as it's within the out of bounds lanes, right, that you should allow the play to continue. So that's how it is supposed to work. Now let's talk about the practical realities of summary judgment. First, let's talk about just what it means for your case. Summary judgment is a big deal, and it occurs particularly in federal courts, in almost every case. The defendant is going to take its shot in getting you kicked out of court altogether. It occurs generally fairly late in the case. So remember, you've filed the complaint now. There may have been some motions argument. There's been, paper discovery. There are depositions. There's a lot of what we call the record, the facts that are now on the record. It doesn't matter, what you say to your friend on the street about your case. That's not in the record. What's in the record are, again, these depositions, these interrogatories, these requests for production, all these discovery tools that we've talked about. Now these facts from the record, it often is hundreds and hundreds of pages of documents and assertions and deposition transcripts. So we're talking about a lot of information. And I remember, if it's a discrimination case and you've had to file at the EEOC and you had to wait at least the 6 months and you had to get your right to sue and you had to file the complaint and you had to go through discovery, it could be easily, even in a fast moving jurisdiction like the Eastern District of Virginia, it can easily be 18 months or more. In some courts that are slower, it could be years before you get to the summary judgment stage. So there's a lot of water under the bridge at this point. So in filing these motions, it's both filing the motion itself that the defendant is going to file, and your opposition. Usually, again, in the employment context, you're the one filing the opposition because the employer is the one saying, "Hey, I want this case kicked out of court." You're saying, "No, it should proceed." It's like writing a novel. It really is. It can be. Even with page limits, the page limits can vary from jurisdiction to jurisdiction, but it can be 30 pages or more. And it's the final product is very dense because you've got a lot of citations. You're citing to the record. And when I mean citing to the record, you can actually attach deposition transcript pages to it. You can attach interrogatory answers to it. So remember, as we were talking about in the discovery context, that's why these are important, because both parties are going to use them to attach to the motion itself. So it can be hours and hours and hours of attorney time and staff time to get this ready. So it can be very resource intensive, almost in every case. So those are the practical realities in terms of what it means for you as the plaintiff going forward. This is not insubstantial. We're talking about climbing a mountain here. And it's really important, too, because this often is the deciding factor in the case. If you win, if you beat them back on summary judgment, then there's much more pressure on the defendant to settle. because most defendants don't want to try the case. They don't want this case before a jury. And what a lot of them are banking on is they're going to beat you in summary judgment. And I'm going to talk about the reason for that in a minute. But in any event, that means a lot of times like that you won't get many significant settlement offers in a case until you've gotten past this point. The one slight exception to this is that often it's not uncommon for the case to be briefed. Okay. So that means the defendant has filed the motion for summary judgment. You filed the opposition for summary judgment. There's always going to be oral argument. You're going to go before the judge and the attorneys are going to argue. There's going to be an argument about the facts, about the law, about the subject of the motion. Now, the court doesn't take testimony then. Nobody's being put on the stand. There are no jurors. This is just before the judge. And then usually, sometimes the judges will do what's called rule from the bench. Like he or she will grant summary judgment or deny summary judgment from the bench. That tends to be less common. Usually a judge will do what's called taking it under advisement, which means he or she's going to sit down and really look at it, and their clerks are going to comb through it, and they're then going to issue, sometimes a lengthy written opinion. That's not always true, but they're going to issue some kind of written opinion, and it can take weeks, months. I mean, it's not unheard of for a judge to sit on this motion for a year. Very rare in the Eastern District, but certainly not unheard of. And during this time, this is a great time for mediation. And we talked about those in some of our other podcasts. It's a great time for mediation because the facts have been almost fully developed at this point. Like it's all out on the table. Both sides are really up to speed on it. If you go before a mediator, then he or she's going to be able to look at all this material. They're not going to look at all of it, but important aspects of it that are pointed, they're kind of offered to them by counsel. And both sides have skin in the game, right? They don't know necessarily how the motion for summary judgment is going to come down. And everybody's tired at this point, right? They've been litigating this for many, many months, if not years. Parties have got they put up a lot of effort into it until this point. And the next stage is either one side loses at summary judgment completely. It's usually the plaintiff, the employee, and then you're kicked out of court unless you decide to appeal, or your case survives, and then you're looking at a jury trial, which is even more work. And defense counsel is looking at this and thinking about, what it will cost to try this case. And a lot of times it's a business decision for the employer. Like, do I want to spend another $100,000, $150,000 to litigate this case? I mean, to try this case, or do I want to settle it? So it tends to be I have settled cases in this kind of in between point. We've had cases where our opposition for summary judgment is 30 plus pages with 100 or more pages of attachments. This is a significant amount of work. Now, here is the real world unfortunate application or truth about Rule 56 motions as courts look at them. Remember, I said courts are supposed to be dispassionate and not insert his or her own judgment here to decide the case. The truth is that it often happens that judges do that. I mean, I'm sure the judges would deny that or don't think they're doing that, but there's no other way to kind of look at this sometimes. And some judges are, known to have a bias, against one side or the other. Often against plaintiffs. Is not always true, but maybe I'm biased in that because I tend to represent plaintiffs, but often against plaintiffs. And it'll show. I mean, sometimes you read an opinion written by a judge in summary judgment, you're like, are we even talking about the same case? Or they'll just rule, rather than issue a written opinion, they'll rule from the bench. You'll have all this work put into it. Both sides will argue, and the judge will say, I find there are no significant issues, no real issues of genuine material fact here that a reasonable juror could find for the plaintiff, and so I'm going to grant summary judgment, and it's over. And some of the reasons that they do that is they know they're pretty protected because, if they grant summary judgment and kick you out of court, yes, you can appeal. And people, it's not uncommon for people to do that. But appeals are even more expensive and time consuming. And I would say in many cases, the plaintiff will lose at summary judgment and just throw in the towel. Enough's enough. Now, some do appeal, but the point is that the judge, has a better than 50-50 shot that his or her decision is not going to be challenged, not because the plaintiff, in your case, the employee, agrees with it, but because, particularly if you've been paying for this out of pocket, looking at an appeal can be tens of thousands of dollars more. If it's on contingency, that means you don't pay anything for your legal fees unless you win. The attorney may be reluctant to push it further unless they think it's a really strong case and they have a really good chance of winning it on appeal. So I'm not saying it's the end of the road or that you can't ever appeal. People do it all the time. But it is a high burden. And then the other reason that they do it is these courts are busy. Federal judges hear all kinds of cases, everything from very serious criminal cases to intellectual property disputes to your employment law case. And they're constantly looking for ways to what's called clean out their docket, right? The cases that they have to decide, because a case that goes to trial, it's going to take at least 2 or 3 days, sometimes weeks of the court's calendar. It's a lot of work, not only for the parties there, but for the court itself. So the court, judges are often looking for, mostly in legitimate ways, like they want to get cases settled, they want to get them resolved, but they're looking for ways to clean out their docket because they've got no lack of cases that they need to attend to. And so if it's kind of on the bubble and they're looking at it and they're looking at their docket, this is a good way to get rid of them. So one of the reasons that it is more difficult to get contingency representation in employment law cases is because of summary judgment. As I kind of laid out, it can be it's very time intensive, hours and hours and hours of attorney and staff time, not to mention your time as the plaintiff. You're going to be talking with your attorneys back and forth and perhaps, helping to review the motion. It is all hands on deck for these things, and you get them filed and you can have a federal judge who will almost, it seems, on a whim, toss your case out. I've certainly had it happen. I've had cases where, I was sure that we were going to win summary judgment. Because remember, if you when I say win summary judgment, that our opposition, that we were going to successfully oppose a motion for summary judgment, because that just means you're going to trial, which is where most cases should go to be decided for jury. I've had cases where I was almost positive we were going to win, only to have the judge rule against us for one reason or another. Now, I will say I have had, not as often as I would like, but I have won cases that I thought that I was going to lose at summary judgment. But the point is that this is a significant hurdle for you as the plaintiff. It's a lot of work. It's a significant hurdle. And you have a fair chance of losing. Again, it depends on the jurisdiction. It depends on the judge. There are some jurisdictions and judges that are known for being, very rarely granting summary judgment. There are some jurisdictions and some judges that are known for granting summary judgment all the time. So this is a really important key part of the case for everyone involved. And painfully, it can involve a lot of work, a lot of effort on your part as the employee and on your, the people who are representing you, only to lose in summary judgment. I don't mean to paint a completely dire picture. Plaintiffs successfully oppose summary judgment all the time. And remember, it's a big win if any of your claims survive, right? Let's go back to our other example where we have a Title VII claim, a Section 1981 claim, and a retaliation claim. Let's suppose we go to summary judgment and we lose on the Title VII claim. The judge says we're gonna kick that out, but you can go forward on the Section 1981 claim, which is also a race discrimination statute, and your retaliation claim. Well, that's a win. You can actually get, you don't get more points for getting more of your claims through. All you need, in many instances, all you need to do is hit on one to be able to recover the same damages, because a Section 1981 claim actually has better damages for reasons that we can go into in a different podcast than a Title VII claim. Same for retaliation. So let's even say that you lost on two claims. You lost on the Section 1981 claim. You lost on the Title VII claim, but your retaliation claim survives. Great. Those are really strong claims. You can still get your lost wages, your emotional distress, your punitive damages. So if you can survive on one claim, and then it's the same kind of calculus for the defense when they're looking at it, if you survive on one claim, there's going to be a trial, and it's usually bad publicity for the defense, and it's very expensive. So you've got a good chance of settling it at that point. So that is summary judgment. I'd say now we're kind of 3/4, if not more, through the process of the litigation process. Most cases are decided here. The plaintiff loses and it's over because they choose not to appeal, or they win and the case settles after summary judgment, because then the next step after this is going to be trial. And our next podcast in this series will be on trial and what that looks like. And then our final one will be on appeals and how appeals work. So I hope you found this helpful. If you did, it would be great if you could give us a good comment on whatever platform you listen to the podcast on. It helps people find us. You can also check out our newsletter. You can go to thecareerrocket.io and sign up for our newsletter there. And you will get an email every week. And we'll have the latest and greatest on employment law, and other tips and tricks for keeping your career on an upward trajectory. Well, I hope you found this helpful. And until next time, good luck out there.